Hi, I'm Eric Perrott with Gerben Perrott in Washington, D.C. And on April 6th, with the IPL Spring meeting at 3:15, I will be a panelist on Reexamining, Reexamination, and Expungement, a practitioner's guide to early days of the Ex Parte TMA proceedings. And I'm really excited to share this information with you and really hope that you'll join us for a really interesting conversation on really cutting edge USPTO policies.
My name is Daphne Epe, and I am a law student at the American University Washington College of Law. I will be a law student reporter at the 2022 American Bar Association IP Law Section Annual Meeting, IPLSPRING. I hope you join us at the conference in Washington, D.C. What is the Trademark Modernization Act and why is it important?
The Trademark Modernization Act was a law that was passed in December of 2020. And in 2021, the Patent and Trademark Office enacted the Expungement and Reexamination proceedings, which was one of the biggest parts of the Trademark Modernization Act. What those are new ways for third parties to challenge registrations that are currently registered with the Patent and Trademark Office. Before, it used to be that you had to file a cancellation or before this, you had to file a cancellation with the Trademark Trial and Appeal Board, which was a inter-parties proceeding, meaning that it was one party against another one, and the government, the U.S. Patent and Trademark Office, was not involved in the fact-finding or anything like that. It was one party versus another. And it was before the Trademark Trial and Appeal Board, and it was mini litigation, essentially. It used the federal rules of civil procedure, and it would be a long, expensive process. The Patent and Trademark Office looked at this and said, well, we should provide a streamlined way of challenging registrations that were not used on specific goods and services to begin with. And that's one of the biggest things that the Trademark Modernization Act's expungement and reexamination procedures are meant to address. Trademarks that are registered that should not have been registered in the first place because they weren't actually using the goods and services that were in their applications when they said that they were. Yeah, there are some nuances to that, but that's the core of what these proceedings are meant to address. As far as their impact on trademark owners and trademark applicants, it has the potential to really change the way that a lot of trademark attorneys and trademark owners are approaching trademark registration. Because in the past, especially with international companies, they will file very broad, sprawling applications, what we call kind of laundry lists of goods and services, because they can file in that way in their home country. And what ends up happening is these very long trademarks that trademark identifications that are way beyond anything that they are actually selling or will actually sell in the United States. And other than directly confronting them through a trademark cancellation proceeding, then there was no real way for a third party to address this. And so now with these new proceedings, you have a streamlined way of being able to challenge these for a fee. It's not for free, and it's something that will evolve over time as far as what exactly goes into these petitions. But it could be a way to get goods that never should have been registered in the first place registered with the removed from applications and registrations with the Patent and Trademark Office.
Hello, everyone. My name is Ili. I'm a law student at Boston University, and I also work on campus at the Office of Technology Transfer right now. I will be a law student reporter at 2022 ABA-IPL section annual meeting, that is IPLSPRING. I look forward to seeing you there, and let's chat later. The newly introduced proceeding offers some key changes. Among them is the requesting party need not identify the real party in interest on those behalf of the petition is being filed, and the standing is not required. What are the pros and cons for the new requirement? Do you think this will spur ex parte expungement?
one of the things that's special about an expungement or reexamination petition is that the person filing it does not need to be a real party in interest. They do not need to have standing. And in fact, even if they were a real party of interest, they don't have to disclose that in the petition. So it really is this open-ended proceeding that allows for anyone who believes that they have evidence that a trademark was not used when the person said that they were using it. So yeah, that could manifest in a few different ways, but essentially that's the core is, when they filed proof of use and they said they were selling hats, shirts, and pants, if they were only selling hats, then someone could potentially petition the Patent and Trademark Office to say, I have evidence they were not selling pants, and I want that removed from their registration. And if the evidence meets the standards of the Patent and Trademark Office for establishing that this was not being sold when the applicant said it was, then they will enact a proceeding that will tell the registrant, you need to actually prove you were selling it and that you have proof that this is actually a product that you are providing to consumers. And if they can't, it will be removed from the registration. That's particularly important because the Patent and Trademark Office has seen a flood of trademark applications over the past 3 or 4 years that are extremely suspicious in the way that they were filed and the scope of the applications. Some of them have had fraudulent trademark specimens, which are the photos that you send with your application to prove that you're actually using the trademark, and they're signing a sworn statement with the Patent and Trademark Office saying that they are selling every single item in this trademark registration. And in some cases, they're just simply not. I personally was the first person to file a expungement proceeding with the Patent and Trademark Office. And it was against a application that I found doing research 3 years ago for an article I was writing. And I found that one of the specimens was a Getty Images photo of a rug that they had just used Photoshop to add a tag onto and put the trademark on the tag. And I did a reverse image search and I was able to put them side by side and said, here's the fake tag, here's the real image that you can license for a licensing fee. And they did not have an actual product for sale when they submitted this from the information that I had. And so that's what I submitted, and it was accepted and enacted by the Patent and Trademark Office, who is now making the registrant prove that they had sales of these products. And if they don't, then it will be removed from the registration. So it's something that is a powerful tool. I was not a real party in interest. This is just something academically that I came across one day. And so this is not something that you don't have to have a trademark that's similar or have any kind of interest to bring one of these, which is a big change from the way that things used to be done with when it came to challenging a registration, where you used to have standing in order to challenge a registration. This is another alternative path now to getting rid of some of these applications that never should have registered in the first place.
Hello, my name is Taylor Dubelle, and I'm a law student at Western New England University School of Law. Prior to my time at Western New England, I got my master's degree in fashion law from Fordham University School of Law, where I primarily focused my studies on intellectual property. I will be a law student reporter at the 2022 ABA-IPL section annual meeting, IPLSPRING. I look forward to seeing you all there. The TMA also allows for the USPTO to set the response period from 60 days to 6 months. How has this impacted response rates?
The Trademark Modernization Act, one of the other things that it did is allowed the USPTO to set flexible response periods. Before the Trademark Modernization Act, it was a 6-month response period for any office actions that were issued by the Patent and Trademark Office. And whenever there's a refusal, whether it's procedural, you have to amend something in the application, or substantive, meaning that there's a prior registration that's stopping that applicant from registering it, and office action issues. And before, it used to be 6 months for every single office action. Well, the Trademark Modernization Act gave the USPTO the discretion to set different dates. Right now, those will not go into effect for at least another year. But where we are seeing it take immediate effect is with expungement and reexamination, that the respondents only get 90 days or 3 months to, I guess, respondents only get 3 months to respond to a proceeding for an expungement proceeding or reexamination. And that is a change from the traditional 6-month response time. And it should have the effect of turning things over more quickly, because we're no longer going to be waiting 6 months for something to get filed in the last 5 days. It's something that we'll need to turn around quicker, which might be a challenge for a lot of the big companies that have to make big decisions, and even small companies. You might need additional time, and there are ways to file extensions, but that's one of the ways that the Patent and Trademark Office is hoping to kind of speed up the examination process to make sure that people who are waiting in line behind them can make meaningful decisions quicker.
Hi, everyone. My name is Christina Yana Crosdale, and I'm a 2L JD MBA candidate at Howard University School of Law. With the first expungement proceeding under the newly enacted Trademark Modernization Act being most recently instituted in early February, how will such precedent benefit future registrations from both the USPTO and prospective registrants' perspectives?
One of the features of the new expungement proceedings is that they can be brought by third parties, and under the rules, they could be triggered by the Patent and Trademark Office themselves. So right now, the focus is really on, will third parties use this? Will a company who's trying to gauge risk or otherwise kind of carve out space for their own trademark, will they file these in order to get a registration narrowed to goods that they were actually selling? The other way that this could potentially be used is by the Patent and Trademark Office to challenge a registration that is issued that got through their system that shouldn't have. And what I mean by this is that the Patent and Trademark Office before this had, once a registration was issued, had no ability to cancel that registration for any of the items that could have prevented it from registering it. So fraud, improper specimens, anything like that. The US Patent and Trademark Office did not have the ability to pull back that registration and re-examine it. They just didn't have that ability. And now there is, I mean, it still needs to follow these kind of narrow non-use grounds, but it does give the Patent and Trademark Office the ability to institute one of these proceedings themselves without a third party asking for it. And so what we might see, and this is kind of very speculative because no one's really talked about this yet, is the possibility for the Patent and Trademark Office to bring these on their own for ones that they are reviewing, where they find out that they, through whatever software they might be using, there might be a fake specimen involved, and being able to address those. I think that's a really interesting way that the Patent and Trademark Office could be proactive in addressing these, and potentially bringing a large number of these against entities that are now known. Years later, we now know that these were filed in a certain way that they shouldn't have. And whether they'll actually use it that way, I think it will remain to be seen, but I think it's a really interesting way that it could be brought is by the Patent and Trademark Office themselves.